Welcome to our presentation on implementation of marine plans. This pre-recorded session has been made available for decision makers who are unable to attend the regional training webinars or anyone else who is interested in the implementation of marine plans. We will cover a fair amount during this presentation. The key thing to remember is that marine plans are statutory. They must be used to inform and guide any decision which directly or indirectly affects the UK marine area. It is a decision maker's responsibility to satisfy themselves that they meet the legal obligations of marine plans and the Marine and Coastal Access Act. This training session can only give an overview of those requirements. We will take you through a brief summary of who the Marine Management Organisation, or MMO, are, and why there is a need to sustainably manage our marine resources and environment. We'll explain why all public bodies need to be aware of marine plans and how our online training tool can help you to use marine plans. We will also provide some policy highlights in our policy walkthrough and tell you more about monitoring and reporting on marine plans. The Marine Management Organisation, or MMO, is the independent regulator for England's seas. The MMO has the 6 main services listed here. We are a non-departmental public body which sits under DEFRA. We licence, regulate and plan marine activities in the seas around England so that they're carried out in a sustainable way. In addition to being the statutory marine planning authority in developing marine plans and licensing marine activities, our responsibilities include the managing of English fishing fleet in respect to capacity and quota, the creation and enforcement of marine conservation bylaws, and being part of the initial response to marine emergencies. Our MMO story for the next 10 years is to be ambitious for our seas and coast, and marine planning supports all 6 MMO services shown here. The marine area is becoming increasingly busy, and there is a need to manage the increasing and competing need to use marine space and resources. With the adoption of all marine plans in 2021, we have for the first time a statutory integrated management planning framework to manage the use, protection and development of the whole English marine environment. The marine plans aim to guide both developers and decision makers to ensure marine activities happen in a sustainable way. Fundamentally, marine plans deliver change in the marine environment. Marine planning makes sure the right activities happen in the right place, at the right time and in the right way in the marine area, placing sustainable development at the centre of all decisions.
We will now move on to marine planning itself, the legislation which underlines marine plans, and a brief overview of the documents which make up a marine plan. There are a lot of organisations that have overlapping functions in the marine area. This figure shows the varied responsibilities of all these and the limits to which their remit extends. As you can see, we all cover responsibilities listed here, from mean high water springs out to 200 nautical miles or the median line with neighbouring countries.
Marine planning is a devolved function in the UK. The Secretary of State for DEFRA is the Marine Planning Authority for England, and functions that are related to marine planning have been delegated to the Marine Management Organisation. The Marine and Fisheries Division of the Welsh Government are the authority for Welsh waters. The Department of Agriculture, Environment and Rural Affairs for Northern Irish waters, and Marine Scotland for Scottish waters. All of these authorities are responsible for producing their own marine plan, and therefore the MMO works closely with these authorities to make sure that all UK waters are being managed in a cohesive system. The Crown dependencies and bordering European countries have also been involved in the development of English marine plans. English waters cover over 230,000 square kilometres. This area was divided into the marine plan areas shown in this map. The marine plan area boundaries were identified by DEFRA using information, expert advice and stakeholder views from a number of public consultations. As a result, 11 marine plan areas were identified which are covered by 6 marine plans: the Northwest, Northeast, East, Southeast, South and Southwest. The Southeast Marine Plan is the only English marine plan that doesn't have an offshore plan area due to the close boundary with the French marine area. The inshore marine plan area ranges from mean high water springs, or the tidal limit, out to 12 nautical miles, and the offshore plan area ranges from 12 nautical miles to 200 nautical miles, or the territorial limit. The first plan to be adopted was the East Marine Plan in 2014, followed by the South Marine Plan in 2018. The Northeast, Southeast, Southwest and Northwest Marine Plans have all been adopted in 2021. Each of these plans have a 20-year horizon, though each is reviewed every 3 years.
What are the benefits of marine planning? As demand for activities taking place in the marine area is increasing, the seas are getting busier and increasing the stress we are putting on the marine environment and marine resources. The marine plans have been developed to provide policy guidance for each plan area to help manage the increasing demands on the marine space and resources. The aim of the plans is to enable sustainable development of our seas. The plans enable sustainable economic growth while protecting the environment through providing a stronger understanding of local marine resources and activities. Marine plans also promote coexistence of activities and allow for multiple activities to happen in the same place, potentially even at the same time. For example, the spatial area of each marine plan consists of the seabed, the water column and the sea surface. Therefore, you could have multiple activities happening at the same time in different dimensions. Or as another example of coexistence, you could have multiple activities happening in the same location but at different times of year. This flowchart introduces marine planning legislation. The 25-year environmental plan required that marine plans were adopted by 2021. In 2009, the Marine and Coastal Access Act provided the domestic legislative basis for the marine planning system. The Marine Policy Statement was adopted by all UK administrations in March 2011, which provided the policy framework for the preparation of all UK marine plans. It contained a range of policy objectives and considerations which were used to inform decision making in the absence of a marine plan. The marine plans translate the Marine Policy Statement into detailed policy and spatial guidance for each marine plan area. Specifically, Section 58 of the Marine and Coastal Access Act 2009 states that all public bodies making authorisation and enforcement decisions which affect or might affect the UK marine area must do so in accordance with the adopted marine plan. All other decisions must be made with regard to the marine plan, for example when a public or local authority creates or reviews a local plan. We will look at this more closely later in this presentation. Marine plans are developed using the marine planning cycle. This is similar to the process used in developing terrestrial plans. Evidence and stakeholder engagement is crucial to each step in the plan-making process. Steps 2 to 5 took place over 3 iterations. At each iteration, there was engagement with local and national stakeholders to gather stakeholder opinion, feedback and evidence to inform policy drafting. This engagement ensured the marine plans are as best informed as possible throughout their development. The iterative process helped to reduce the amount of challenge that occurred at the public consultation phase, as stakeholders had been included in the process from the beginning of development. This approach also enabled the MMO planning team to focus on locally identified issues and opportunities. The resulting plans were laid before Parliament to be signed off by the Secretary of State for the Environment and adopted as the statutory guidance informing marine development. It is worth noting that, unlike terrestrial planning, the marine plans may not require an independent investigation. The only time a marine plan will undergo an independent investigation would be if the Secretary of State for the Environment requests one, or if there are any serious issues raised that cannot be resolved during the consultation process.
In marine plan development, we also work closely with neighbouring devolved administrations. For Scotland, the Scottish National Marine Plan was adopted in 2015. For Wales, the Welsh Marine Plan was adopted in 2019. As all marine plans are underpinned by the Marine Policy Statement, they are all working towards the same high-level marine objectives around the entire UK, so that the system works holistically. We have been working closely with the Welsh and Scottish governments through the entire marine plan development process to ensure our marine plans are compatible with the cross-border marine plans. Using the South-West Marine Plans example, the marine plan contains marine plan policies, a plan area vision and objectives. It is supported by the technical annex, which contains more detailed notes on each of the policies, including why the policy exists, what it aims to achieve, and how to implement or use a policy to aid decision making. This is supported by a sustainability appraisal and habitats regulation assessment.
To put marine planning into context, our marine planning team has similar functions to a local planning authority's strategic planning team, and our marine licensing team has similar functions to a development management team. As this graph shows, the remit of terrestrial planning authorities extends down to mean low water springs, and the MMO's remit extends to mean high water springs. This means that there is an overlap of the intertidal area, where an applicant may need both planning permission and marine licence. However, there are also a number of terrestrial developments or aspects of terrestrial developments that can impact upon the marine area, and these need to have regard for the marine area and in turn the marine plan policies. The terrestrial overlap ensures holistic management of marine and terrestrial environments. This is reinforced by the duty to cooperate introduced under the Localism Act. For the future, the MMO would welcome any initiatives to join up elements of local and marine planning to deliver integrated coastal zone management, particularly relevant with climate change and impacts upon coastal defences. To work together in this overlap, DEFRA created the Coastal Concordat. The Coastal Concordat is a framework so that decision makers can coordinate processes for coastal development consents. The framework is designed to streamline the process where multiple consents are required from multiple decision makers, thereby saving applicants and decision makers time and resources. It is DEFRA's aim under the 25-year Environment Plan to have all coastal authorities signed up to the Coastal Concordat.
We will now move on to providing an overview of marine plan implementation. By implementation, we primarily mean using marine plans. It is a legal requirement for marine plans to be considered in all decisions that affect England's marine area now and into the future. Decisions that take account of marine plans have a reduced risk of legal challenge, are informed by the best available evidence, and are considered against wider context, both on land and at sea. If decisions take account of marine plans, England's marine area will be managed sustainably and time and money can be saved by all parties. Successful implementation of marine plans will help to shape the prosperity of the region now and into the future, draw together the social, economic and environmental benefits across land and sea, and strike a balance between local and national aspirations. Alongside this, implementation will also allow us to understand how effective the plan and policies are when monitoring and reviewing. The principal means through which the marine plans are applied will be through the decisions made by public authorities. For example, a Minister of the Crown, the MMO, a local planning authority or another public body. Decisions these authorities make need to be in line with Section 58(1) and Section 58(3) of the Marine and Coastal Access Act. Section 58(1) requires all public authorities to take authorisation or enforcement decisions, for example on an approval, confirmation, consent, licence or permission, which affect or might affect the UK marine area, to do so in accordance with the marine plans unless relevant considerations indicate otherwise. Section 58.3 requires all public authorities making other decisions which are not authorisation or enforcement but can still affect the marine area to have regards to the marine policy statement and marine plans. This means that all other public authority functions, such as the adoption of local plans, revisions of management plans for areas of outstanding natural beauty, must consider and have regard to marine plans under Section 58.3. All public authorities must conform to Section 58 of the Marine and Coastal Access Act. There is no distinction between coastal or inland authorities which have no coastline or tidal watercourses. However, as with all planning regimes, there is some discretion allowed in decision making. It is possible to go against the marine plan under Section 58.2. Section 58.2 allows for decisions not in accordance with the plan as long as reasons are stated. This could be in cases of imperative reasons of overriding public interest or other material considerations, such as a change in scientific understanding which could render specific plan policies inappropriate. Nationally significant infrastructure projects, or NSIPs, where the decision is made at the Secretary of State level, are considered under Section 58.3 and 5 of the Marine and Coastal Access Act, rather than Section 58.1. This is due to the fact that the relevant national policy statement carries greater weight than the marine plans. However, they still have to have regard to the marine plans under Section 58.3, and the MMO are a statutory consultee for development consent orders, under which there will be a deemed marine licence. Examples of decisions that must be made in accordance with the marine plan include the MMO approving a proposal for a marine licence, the development of bylaws for the protection of marine conservation zones, or the granting of a wildlife licence. Decisions made by the Environment Agency, such as permitting flood or coastal defence works, and environmental permitting regulations, such as permits dealing with water discharges, waste, regulated industry, and water abstraction. Or local planning authorities determining relevant planning applications in the intertidal area, possibly above mean high water springs, depending on circumstances and potential impact upon the marine area. There are two types of decisions made under Section 58.3. In the first instance, we have decisions under nationally significant infrastructure projects, for example, substantial port developments or offshore wind farms producing over 100 megawatts. Secondly, decisions that may affect the UK marine area, for example, the adoption of a terrestrial local plan that goes on to inform a relevant authorisation or enforcement decision. This can include, but is not limited to, terrestrial policies, which include policies on coastal change, waste management plans, certain local authority neighbourhood plans, and so forth. As a guide, we advise the following points are followed when using marine plans to help inform an authorisation or enforcement decision. As with terrestrial planning, it is best to consider the marine plan and associated policies at the pre-application stage. The Coastal Concordat is especially useful here as it provides a roadmap to join up and simplify the process and reduce burdens of consenting a development which may require both a terrestrial planning consent and a marine licence. The marine plans need to be considered as a whole, as it is likely that several plan policies will be pertinent to any proposal. Public authorities should take a proportionate risk-based approach to decision-making using the relevant marine plan policies. It would also be beneficial for local planning authorities to mention in any decision notices instances where marine plans have been considered. This aids our understanding of the effectiveness of plan policies. A guide is available on the MMO website which shows a worked example of how the MMO uses marine plans as part of the marine licence decision-making process under Section 58.1 of the Marine and Coastal Access Act. Although the terrestrial planning regime is currently subject to a wide-ranging review, we still operate under current existing guidelines and obligations, such as the duty to cooperate. Section 58.3 decisions refer to the exercise of any function capable of affecting the whole or any part of the UK marine area. This includes consideration of the impacts of local plan strategic objectives on the marine environment. The MMO is committed to working with the local authority planners, and we are happy to engage in any statement of common ground requests as an additional signatory, bearing in mind our remit only extends to those matters of strategic overlap between the marine and terrestrial realms. The Planning Advisory Service also provides a template checklist to ensure marine plans have been considered when preparing to submit a plan for examination to the Planning Inspectorate. We recommend early engagement with the MMO where possible. As with Section 58.1, there is a guide available on the MMO website which indicates how planning authorities and other decision makers could recognise and incorporate marine plan considerations into local plan making. The Explore Marine Plans is a digital service developed by the MMO. It is a multi-layered system which allows spatial identification of any proposed works and automatically scopes in all relevant marine plan policies. Explore Marine Plans is the Marine Management Organisation's mapping service, which can be used to find marine planning information for England, including data on marine licences, environmental designations and marine plan policy information from regional marine plans. The tool is a key component of marine planning and should be used alongside the published marine plans. With Explore Marine Plans, you will see two tabs, Map Data and Marine Plan Policies. Each of these tabs provide different functions. The Map Data tab contains recently published marine activities data that can be turned on in the map to aid with implementation of the marine plans. And the Marine Plan Policy tab provides a drawing tool function to view marine policy information in the area selected. By drawing a polygon of the area of a proposed development, the Explore Marine Plans tool will present an option to list all marine plan policies which apply to that spatial location. Explore Marine Plans also includes contact details for marine planners and quick access to the marine plan documents where each policy has detailed implementation guidance. Rather than give a demonstration of Explore Marine Plans here, we recommend you visit our website where we have developed a how-to video guide. You can also visit the Explore Marine Plans webpage to experience the various functionalities of the site for yourself.
Here we will introduce you to the broad types of marine plan policies and how they would apply by way of a walkthrough example of some plan policies. Policies are the test which deliver sustainable change in the marine environment. Furthermore, plan policies indicate how that change should be implemented and monitored. Each policy is a test of the proposal. As with the terrestrial realm, plan policies test each marine licence application in order to assess how a proposal meets the vision and objectives of the marine plan. At the MMO, we ask that an applicant front-loads any required information at the start of the process. However, as with terrestrial planning, the MMO uses a proportionality principle when assessing applications in order to streamline the process as far as we can. Some policies apply across the whole of the plan areas, others just in the inshore or offshore plan area, and some apply to defined spatial areas. Plan policies and relevant supporting information have been expressed spatially where possible by using maps within each published marine plan and the Explore Marine Plans online service. Marine plan policies are the means by which the marine plan objectives are achieved, how the overall outcome of the marine plan are arrived at. Policies apply to new activities. The plans do not apply retrospectively. Marine plan policies need to be applied as a whole, rather than as individual policies. This allows social, economic and environmental factors to be considered in the decision-making process. It moves decision-making away from sector-specific and into plan-led management. There are a mix of marine plan policies. that vary depending on where, when and how an activity takes place, and vary in strength from guiding to definitive, dependent on the evidence base, stakeholder appetite, government policy and other factors. We recommend proponents and decision makers follow the policy order prioritisation walkthrough process included within the Marine Plan. This is a 6-step process which allows policies to be assessed within relevant context. The Marine Plan identifies which policies fall within which category. I am going to run through a quick example of some of the policies and how a decision maker would apply them when going through the decision-making process. It is worth reiterating again that the Explore Marine Plans digital tool will automatically identify which policies apply once a polygon is drawn to represent the spatial extent of any proposal. The first step is to assess policies which apply or are relevant across the whole of the inshore and offshore plan areas. This policy example applies to climate change. Policy CC2, which is an example of a policy which applies to all marine licence applications and terrestrial developments that could be impacted by climate or coastal change. The second step is to look at those policies which show a clear preference for certain activities in defined locations. These policies are spatial and provide support for relevant activities and precludes other activities or requires them to be compatible. The policy example here shows a preference for aggregate extraction in defined areas. Policy AGG1. Other proposals must show their compatibility with that purpose in order to proceed. The third step is to look at those policies which support existing use of the marine area. These policies do not preclude other activities, but they do require other proposals to work through a number of steps to reduce impacts on existing activities and to ensure coexistence and the management of any potential conflicts. This policy example requires that new proposals will manage the effects on existing priority habitats and species within the marine area. Policy Bio 1. The fourth step is to look at those policies which safeguard areas for future preferred development. These policies either support a particular sector or require an applicant to work through a number of steps to prevent negative impacts on future preferred activity. This policy example aims to safeguard potential areas of aquaculture production from sterilisation from inappropriate development. Policy AQ1. The fifth step is to look at those policies which directly support certain sectors, support diversification, skills and enhancement, or employment across all activities. The example policy here links marine and land-based activities. This is an example where land-based and marine-based planning can cooperate to deliver proposals which benefit society and the economy. Policy Inf 1. The sixth and final step is to look at those policies which support preferred methods or best practice in delivering a particular proposal. The example shown here is the preferred method for the installation of undersea cabling. Policy CAB 1. Marine plan policies are applied bearing in mind any relevant considerations. This is where the differences and uniqueness of each plan area can be accommodated in line with the individual vision for each plan area.
As an example of regional variations, the 4 marine plan documents contain broadly the same policies. However, this does not mean that the plans will be applied in the same way. Here is an example to show how the evidence that underpins the plan policies would lead to a very different decision in each plan area. you can see that the high-density navigation routes and strategically important navigation routes are incredibly different in each marine plan area. Therefore, this policy will have different impacts on decision-making in each area. In addition to this, as time passes or different activities take place in each marine area, the policies may need to be applied differently. An evolving evidence base ensures that marine plan policies do not go immediately out of date.
I will now explain more about the monitoring and reporting process for marine plans, and how you can provide feedback on the use and consideration of the plans. The MMO has a legal requirement to monitor the marine plans under sections 54 and 61 of the Marine and Coastal Access Act. Monitoring of the implementation of marine plans informs the MMO how plans are being used and allows us to measure the impacts of plan-led management on the English marine waters, in particular whether we are meeting the targets of the high-level marine objectives. The Northeast, Northwest, Southeast and Southwest Marine Plans approach to monitoring document describes how these marine plans will be monitored and will in time be supported by a separate annex of indicators that will set out detailed indicator descriptions, including quality assurance undertaken. The approach to monitoring adopted by the Marine Management Organisation is informed by the HM Treasury Magenta Book, and the development of monitoring indicators is informed by recommendations made by the Sustainability Appraisal. Our marine plan monitoring includes monitoring indicators, annual monitoring surveys, and case studies. As a valued stakeholder, the MMO would like to invite you to participate in our annual surveys to help us gather information about the use of marine plans. The surveys are particularly relevant for decision makers. However, following feedback, we have updated the surveys to make them more accessible to all stakeholders. As a decision maker, if you refer to marine plans in your decision notices, it would help us if you were to complete a monitoring survey to inform us so that we are able to make the links between marine plan use and policy application. The survey also asks questions about your perception of policy effects. As part of our marine plan monitoring work, we also conduct follow-up interviews with some stakeholders. We are keen to speak to and get feedback from local planning authorities specifically. If you'll be willing to participate, or if you're aware of any barriers to your engagement in this process, please get in touch via our mailbox. The surveys are usually launched in the autumn and may take up to 1 hour to complete. These surveys are your opportunity to continuously feed into marine plan development. Please email us to receive the surveys. No more than 3 years after its adoption, the MO produces a report for the consideration and agreement of the Secretary of State to lay before Parliament on the individual marine plan. Every 6 years, the report is on all marine plans together. Reporting to Parliament includes the effects of policies, the effectiveness of policies in securing plan objectives, and progress towards regional objectives and the Marine Policy Statement. There is a duty to report on marine plans that have been prepared and adopted, intentions for their amendment, and intentions for the preparation and adoption of further marine plans. The Secretary of State then makes a decision as to whether each marine plan should be amended or replaced, or left as it is. I hope that you found this presentation useful. Please contact us if you would like more information on the marine plans or on any of the resources we have referred to throughout this presentation. Thank you for your time today.